Hello, law students and legal practitioners. Today, we will analyze the case of Ronquillo et al. Versus Roco et al. GR number L-10619 decided by the Supreme Court on February 28, 1958. Let's begin. Doctrine of the case. An easement of right-of-way is classified as a discontinuous easement, even if it is apparent or visible. Under both the Old Civil Code and the New Civil Code, discontinuous easements, whether apparent or non-apparent, cannot be acquired through prescription and may only be constituted by virtue of a title. Discontinuous easements are those that depend upon positive human acts for their exercise and are used only at intervals, rather than continuously. Since acquisitive prescription requires possession that is continuous and uninterrupted, a right whose use is inherently intermittent cannot satisfy this legal requirement. The provisions of Act No. 190, Code of Civil Procedure, on prescription do not repeal or modify this civil code rule. Despite Act No. 190 recognizing prescription over real rights, it still requires actual, open, public, adverse, and continuous possession, which is legally and logically incompatible with the nature of an easement of right-of-way. Accordingly, unless and until the civil code is amended or clarified, the easement of right-of-way remains non-acquirable by prescription, regardless of the length of its use. Here are the relevant facts of this case. The plaintiffs, Leogario Ronquillo and others, owned residential properties situated in such a way that, for convenient access to Igualdad Street in the public market of Naga City, they regularly passed through a road or passageway traversing the land of the defendants and their predecessor in interest, Vicente Roco. According to the plaintiffs, they and their predecessors had been using this road openly, continuously, and without interruption for more than 20 years, and such use had allegedly been recognized, tolerated, and respected by the defendants and Vicente Roco as a private legal easement of right-of-way. However, on May 12, 1953, the defendants allegedly began constructing a chapel directly in the middle of the alleged right-of-way, thereby partially obstructing and impairing the plaintiffs' access to the street and market. This construction was claimed to have disturbed the long-standing exercise of their supposed easement. The situation worsened on July 10, 1954, when additional defendants, acting with the approval of José Roco, allegedly planted wooden posts, fenced the area with barbed wire, and completely closed the road, using force, intimidation, and threats. As a result, the plaintiffs were allegedly barred from passing through the road entirely. The plaintiffs filed an amended and supplemental complaint, asserting that they had acquired a legal easement of right-of-way through prescription due to prolonged use. The defendants moved to dismiss the complaint, arguing that it failed to state a cause of action, as an easement of right-of-way cannot be acquired by prescription. The trial court agreed with the defendants and dismissed the complaint. Since the case involved only a pure question of law, the appeal was brought directly to the Supreme Court. So the issue of this case is whether an easement of right-of-way may be acquired by acquisitive prescription. No, an easement of right-of-way cannot be acquired by prescription. The Supreme Court held that an easement of right-of-way, being discontinuous in nature, is not susceptible of acquisition by prescription, regardless of the length of time it has been used. Under Articles 532, 537, and 539 of the Old Civil Code, and Articles 615, 620, and 622 of the New Civil Code, easements are classified as continuous or discontinuous. Only continuous and apparent easements may be acquired by prescription, whereas discontinuous easements, whether apparent or not, may be acquired only by virtue of a title. An easement of right-of-way is classified as discontinuous because its use depends upon positive acts of man, such as walking or passing through the land, and cannot be exercised incessantly. Civil law authorities such as Manresa and Sanchez-Roman uniformly explain that a right-of-way cannot be continuously enjoyed and therefore lacks the continuity required for prescriptive acquisition. The court further held that Act No. 190, Code of Civil Procedure, does not change this rule. Although it recognizes acquisitive prescription of real rights, it still requires actual, open, public, adverse, and continuous possession. Since continuity is likewise required under Act No. 190, and since a right-of-way cannot be continuously possessed, prescription cannot apply. In this case, although the plaintiffs claimed to have used the passageway for more than 20 years, such use was necessarily intermittent, occurring only when they passed through the land. The court stressed that frequency of use does not amount to continuity of possession in the legal sense required for prescription. Because the plaintiffs relied solely on prescription and failed to allege or prove the existence of a valid title creating the easement, their claim had no legal foundation. Consequently, the amended and supplemental complaint failed to state a cause of action, and the trial court correctly dismissed the case. That's all for today. Thank you for listening and happy learning. See you again for our next case discussions.